By now, you've read or heard about the Supreme Court judgment which affirmed the Court of Appeal's decision sentencing Mr. Lawan to 5 years imprisonment. But what is most likely is that you do not understand the legal intricacy of the matter, which took 11 long years from High Court all the way to Supreme Court. This video seeks to break the legal intricacies down to your understanding. It is good to understand that this case is a case that has tested the criminal justice system of Nigeria with numerous issues and appeals, starting from 2013 down to 2024. That is a whopping 11 years. So let's get right into it. You will remember that Mr. Lawan was the then chairman of the House of Representatives ad hoc committee on the investigation into the fuel subsidy scam in 2012. During the fuel subsidy investigation, Mr. Otedola's company was listed as one of the companies on the fuel subsidy scam list. But Mr. Farouk Lawan approached Mr. Otedola and demanded a $3 million bribe in order to remove Mr. Otedola's company's name from the list. With the connivance of the law enforcement agencies, Mr. Otedola gave Mr. Farouk Lawan a marked $500,000 with the agreement that the name of his company will be delisted from this subsidy list. Mr. Lawan and Mr. Emmanuel, his accomplice, were later arrested, and they were arraigned on a 7-count charge pursuant to the Corrupt Practices and Other Related Offences Act. Upon their arraignment, the two accused persons filed an application on the 2nd day of April 2013 in which they sought an order of the trial court to quash the charge brought against them. The FCTI court ruled against them, and they appealed. The Court of Appeal also ruled against Mr. Lawan. It is good to state at this juncture that Mr. Lawan was originally arraigned before Honorable Justice Oniyangi in February 2013. But upon the elevation of Justice Oniyangi, the defendants were later arraigned before Honorable Justice Banjoko. A petition was written against the judge, which made Honorable Justice Banjoko recuse herself. The matter was later assigned to Honorable Justice Otaluka. Before Honorable Justice Otaluka, the respondent took his plea for the 3rd time. Mr. Lawan continued his case at the High Court. Immediately after the prosecution closed its case, he raised a no-case submission, which the High Court judge ruled against him. Mr. Lawan appealed the no-case submission to the Court of Appeal. The Court of Appeal, in turn, ruled against him. He returned back to the High Court and continued his case. Furthermore, the FCT Chief Judge transferred the case from the judge hearing it to another judge. But Mr. Farouk Lawan appealed, and the Court of Appeal erred in its favor, ordering that the matter be heard by the judge that started it, and it should be given accelerated hearing. The judge that started it here is Honorable Justice Otaluka. When all was said and done, the FCT High Court in its judgment sentenced Mr. Farouk Lawan to 7 years imprisonment and ordered him to restitute the $500,000 he collected as bribe back to the federal government. Mr. Farouk Lawan appealed the judgment to the Court of Appeal. The Court of Appeal discharged and acquitted Mr. Farouk Lawan on some counts, thus reducing the sentence from 7 years down to 5 years. Mr. Farouk Lawan appealed to the Supreme Court. On the 26th of January 2024, the Supreme Court, as the final court, upheld the decision of the Court of Appeal and maintained that the sentence of Mr. Lawan to 5 years imprisonment stands.